begin for the day. Yesterday, I had mentioned that my dear Lordship had asked me to speak to the Solicitor General and requested to be present. Is that royalty matter, my lords, where one matter was not detagged?
Mr. Solicitor, that oil company matter remained to be detagged. So
it needs to be detagged.
So I just told him talk to the learned solicitors.
Yes, it needs to. I'll provide word by
the picture wale group mein. Need to be detagged. Oil company.
I'm waiting.
Your Lordship, please. This volume 2 is my brief note submissions. I wouldn't take more than 15 minutes. And before I do that, I thought there's another volume 4D, which I did not refer to the other day.
We don't have that.
It's just volume 4D is a text except of a book on meaning of meaning. It's about linguistics. I have placed chapter 6 for a interesting reading that we understand sometimes about definition, how we have some issues. I don't propose to read it at great length. There are a couple of pages, let me just draw your Lordship's attention to that. Before I come to that, let me take your Lordship to volume 2F. We did a little research on the colonial period understanding of intoxicating liquor. And that gives us some insights on how it was understood then. So let me quickly read a few paragraphs of my written note. In the first part, I say that the use and recognition of use of alcohol liquids for other than potable purposes has been a subject matter of discussion during the colonial period. The literature available on this subject gives us insight as to the distinction between classes of alcohol with reference to their uses. It's submitted that entry 8 is based on the said distinction. The literature plays along with this note show that there is nothing in support of the proposition that intoxicating liquor was understood to include all classes of alcohol liquids. Matters of trade and commerce, supply and distribution, etc., referred to in entry 33, or in relation to the products of an industry under the control of the union. The nature and extent of trade and commerce, etc., will differ from product to product. Clause A of entry 33 of list 3 came in by third constitutional amendment. Enacting such a field of legislation in the concurrent list can be understood from the need for flexible distribution of legislative scope within union under states. Entry 33 is therefore a classic example of Article 254 proposition. Once it is understood that neither entry list 2, whichever way it is construed, and keeping in mind entries 26 and 27 of list 2, which are subject to provisions of entry 33, laws made by Parliament under the authority of the two branches, namely entry 50 list 2 and entry 33, will occupy the declared field. The use of the phrase, that is to say, occurring in entry 8 only refers to the range of activities concerning one class of alcohol, namely intoxicating liquor, and is not referable to other classes of liquor, trade, commerce, supply, distribution. These are all activities. The approach adopted in Calcutta Gas based on resolving conflicts between entries in the same list does not appeal to logic. The mere fact that entry 25, gas and gas work, is treated as a distinct entry does not mean that any part of dealing with gas and gas work cannot even conceptually fall under entries 24, 26 and 27 of list 2. The emergence and use of gas processes and industries related in such use can be the only reason for a special attention to be paid to gas and gas works. The logic applied in Calcutta Gas cannot be extended to entry 8, list 2. I'll go to the literature in the subject. Let's kindly turn to paragraph
Part 2.
3. It submitted India the use of alcohol for industrial purposes and regulation for both subsequent to use and regulation of alcohol for the purpose of intoxication. To understand the regulation of liquor in India, it needs to be understood that colonial laws of the 19th century were guided by twin objects of generating revenue on the one hand and checking intemperance of people towards safeguarding their morality. The reference is available at footnote number 2. The said purpose of the Akbari Acts, for instance, the Bombay Akbari Act, can be evinced from the contents of the reports on administration of the Abkari Department of the Bombay Presidency, Sindh and Eden. For instance, para 6 of the report of 1880-81 notes progressive increase in Abkari revenue, which is accompanied by decrease in drunkenness. Notably, the details of revenue collections notes 4 branches of Abkari revenue, that's foreign liquor, country liquor, intoxicating liquor, and miscellaneous. That submitted that even though all categories of liquor were considered consumable, intoxicant liquor was considered a separate class of liquor that is ordinarily and regularly consumed, which is administered and monitored separately. In the report of the Administration Abkari Department of the Bombay Presidency, Sindh and Eden, published in 1894, the source of the revenue are listed as 1. The principal source of Abkari revenue on this presidency are A. Manufacture and sale of country liquor, which term is for the present purpose to be understood as exclusive of malt liquors brewed in India, and the special descriptions of liquors referred to under clause B below. The manufacture and sale of malt liquors and of certain special descriptions of country liquors excise at rates leviable under the Indian Tariff Act on liquors imported from foreign liquors. C. The sale of foreign liquors. D. The manufacture and sale of intoxicating drugs other than opium or preparation of opiums. The country liquor taxed and consumed are 2 kinds, distilled spirit and toddy or the sap of palm tree. Then, next paragraph. The liquor in question during the first century of colonial rule was only the liquor that ordinarily being consumed. It's also worth stating the alcohol proof prescribed was never as high as 90% proof as is being discussed today. Even as late as 1919, the report on the administration of the Excise Department, Abkari and opium in the Bombay Presidency, Sindh and Eden notes in para 4. There was no change in the prescribed sales strength of country spirits sold, namely 25%, 30%, so and so. The policy discouraging the consumption of stronger spirit was further pursued by the restriction, where feasible, of additional shops. Then paragraph 7. It was at the turn of the century that alcohol achieved a different dimension. Then turn to paragraph 8. With the increased use of alcohol emerged from the issue of liberal taxation for industrial alcohol and the conundrum that's being faced with the Honorable Court as to what constitutes industrial alcohol. This issue was considered by the Industrial Alcohol Committee in the report of 1920, where it observed there is some difficulty in finding a satisfactory definition of the term industrial alcohol and in avoiding the purely subjective definition of alcohol intended for industrial purposes. At first sight, this would appear to be the only possible description, as there is no intrinsic difference between alcohol intended for portable and non-portable purposes. Possibly the best definition of alcohol, which is exempted from the excise duty leviable on portable spirit on the ground that is intended for non-portable purpose. This will cover both pure alcohol and alcohol, which has been denatured, that is rendered unfit, more or less completely for human consumption. It will also cover the use of alcohol in experiment and research and distinct from purely commercial uses, where the object is to place the finished product on the market by will, exclude the use of alcohol in hospital and in the preparation of medicines and tinctures. Industrial alcohol, as defined above, is alone dealt with this committee. The British Inter-Departmental Committee on so-and-so paragraph for the report that all alcohol for power or traction purposes should be described as power alcohol. This is satisfactory so far as it goes. And we have made suggestions for the definition and regulation of such power alcohol. At the same time, they suggest the term industrial alcohol is unsatisfactory on the ground that some section of the community believe it to be alcohol for the working man. Such misapprehension is not likely to arise in India. Power alcohol is a subdivision of industrial alcohol, and we see no reason to abandon the logical classification. The report also made certain recommendations for preparation, transport, and taxation of power alcohol, that is industrial alcohol used for fuel or motor vehicle. Then, paragraph 5, the report, the final report of it. All local governments should be required to revise the rules regarding other forms of industrial alcohol so as to clearly discriminate from alcohol intended for portable purposes and to provide for grant of special licenses for experiments in the production and use of alcohol, for the use of rectified suspicion or specially denatured spirit in industries. And they should also bring their rules into conformity in various minor matters, especially as regards denaturation tests, the permissible quantities of private possession, and the retail strength of ordinary denatured spirit. So that gives us a very important insight as to the pre-colonial understanding and how it has not faded away with intoxicant liquor being treated as an entry in item number entry 8. There are only few observations I want to make. Then constitutional debates, my learned solicitor will extensively deal with that in volume 7. It's also understood the same way. And for instance, CJI talks about it in his volume 2. Intoxicating liquor has meaning liquor which is consumable. And then Justice Sinha notes about it in the judgment. So there are aspects which the solicitor, learned friends will deal with. I thought this is an important insight about what happened, which went into the understanding of intoxicating liquor. So if you also look at volume 4D, that few pages there, the question of difficulty with definitions. It's a very important insight as to how we have all the difficulties in definitions. And at the opening page, there's a quote from Oscar Wilde's 4-act play, Lady Winderman's Fan. It's very interesting. So this is how it reads. Do as a concession to my poor wits, Lord Darlington, just explain to me what you really mean. I think I had better not, Duchess. Nowadays, to be intelligible is to be found out.
Okay, thank you, Mr. Attorney General. Thank you.
Very well.
Thank you, Mr.
Very well.
Yes, Mr. Solicitor.
May I take the Lordship's leave? May I take the Lordship's leave?
Wait, please. But my submissions are in volume 2D.
Volume 2?
2D, my lord. Earlier I have filed 2C, which is modified. So kindly ignore 2C, my lord. If not possible, technically I will delete 2C so that there is no confusion. There is nothing, my lord.
But yeah, it may be just updated and...
Yes, that's all. There is nothing
There's no
which
duplication.
has wrongly gone into 2C and I am trying to. This is updated, brought in a little better flow.
We just said 2C to be ignored.
Yes, 2D. But I would wish to read, my lord, the questions first, and the reason is this. Lord, except one question which directly concerns alcohol as a product. Rest of the questions are on interpretation and interplay between the Constitution of India and the Industrial Development and Regulation Act. Though your lordship, my lord, the Chief Justice was right that many of the products are de-licensed now, but many of the products continue to be under the licensing era. Even alcohol partly is under the licensing era, and therefore whatever your lordship ultimately adjudicates is bound to affect the operation of IDRA vis-a-vis the scheme of the Constitution, and there are certain paramateria entries like 52. Please come to, my lord, page, PDF page 2. These are the questions. Does section 2 of the IDRA have any impact on the field covered by section 18G of the said Act or entry 33 of list 3 of the 7th schedule? Look, this is a generic question. Does section 18G of the Act falls under entry 52 of list 1 of the 7th schedule or is covered by entry 33 of list 3 thereof? In absence of any notified order by the central government under section 18G of the above Act, is the power of the state legislature in respect of matters enumerated in entry 33 of list 3 ousted? Does the mere enactment of section 18G of the above Act gives rise to a presumption that it was the intention of central government to cover the entire field in respect of entry 33 of list 3 so as to oust the state's competence to legislate in respect of matters relating thereto? Does the mere presence of section 18G of the above Act oust the state's power to legislate in regard to matters falling under entry 33A of list 3? Lord, up to here, these are generic questions, Lord, which would hold the field, my lord, forever till, my lord, it is, my lord, doubted or referred something. But IDRA, any scheduled industry being brought under it, my lord, would be covered by what your lordships would now decide. And last question, does the interpretation given in synthetics chemicals, that is synthetic 2, my lord, in respect of section 18G of the IDRA, correctly state the law regarding the state's power to regulate industrial alcohol as a product of the scheduled industry under entry 33 of list 3 of the 7th schedule of the Constitution in view of clause A thereof? Now, please come to, my lord, page 3, which are the existing statutes under entry 52 list 1, which would directly be affected by the first questions except the last one. The Coffee Act, Rubber Act, the Rice Milling Industries Act, the Cardamom Act, Coconut Development Act, etc., etc. But this is an illustrative list. There may be other laws also. This is only to point out that kindly do not consider this question only from the prism of alcohol industry. This would be, my lord, a wider question affecting every scheduled industry which is included in the schedule appended to this act. Now, Lord, some of the things, my lord, which are never pointed out to your lordships right from Tikaramji, and that is why, my lord, I would ultimately say Tikaramji is wrong. Lord, I am placing for your lordship's consideration. The first thing, my lord, which is never pointed out either in Tikaramji or in any subsequent judgments which follows Tikaramji. None of the judgments, my lord, your lordships, had the assistance of these facts, these position in the Constitution. And that is, so just giving an example, Lord Tikaramji says that industry has a restricted meaning it includes manufacturing activities. It doesn't say why. There is no logic, there is no rationale given, there is no discussion. But in the Constituent Assembly debate, Dr. Ambedkar elaborates the term and width of the word industry. But there are 4 compartments in which, my lord, your lordships will have to be assisted to reach a correct conclusion. My lord, this is not a center state issue. So, my lord, this is not, my lord, an adversarial position. I am taking a position to assist your lordships. Because UP is here, my lord, Maharashtra is here, there is nothing political or, my lord, any federal dispute, etc. So, there are 4 stages your lordships will examine in interpreting each entry. First is, my lord, called devolution rules. My lord, in 1990, Government of India Act was passed. Yes. Which bifurcated the subjects between the federal government, which is the central government in the present parlance, and the provinces, that is the state government in the present parlance. That is called devolution rules. Yes. Thereafter comes Government of India Act 1935, where again this bifurcation of legislative competence between federal government and the provinces took place. Third is the draft constitution prepared by the drafting committee chaired by Dr. Ambedkar. How they used certain expressions qua each provision and qua each entry. Now, that draft entry or a draft constitutional provision was debated, and how it takes form of what the constitution is at present. Lord, I have attempted to show on every provision which is coming for your lordship's consideration, all the four. And if your lordship's would, subject to your lordship's approval, I can say, if your lordship finds that if this would have been pointed out right from Tikaramji, or at least at some stage, Tikaramji would have been differently decided. Lord, please come to page 5, page 6. Lord, I am skipping what is not, what I have already orally pointed out. Lord, I come to entry 52 first. Your lordships have PDF page 6. My Lord Justice.
Yeah.
Lord, para 6 I'll read with your lordship's permission. Some of the industries have always been considered to be necessary to remain under the central control if it is found to be in national interest. But throughout, there is a chain of 3 considerations. Industry, the functioning of which has a national interest. B, the industry, the functioning of which needs decision making at the pan-India level. And 3, the industry, the functioning of which needs the regulation in such a fashion that the product is equitably distributed. Lord, your lordships are aware, my lord, as we pointed out in mines matters also. Lord, some of the states are endowed with some of the most important resources. Rest of the states do not have the benefit. And if the constitution feels that it is to be left to the parliament, that a particular industry should be centrally governed, not provincially governed, because provincial governments would take provincial perception, and the central government would have a holistic perception. So those industries have always been conventionally, traditionally, and constitutionally be under the center. Lord, now corresponding entry in the devolution rules. The first devolution rules made under Government of India Act 1999. That is
Solicitor, all our young juniors, stand day after day. I've been noticing, with their laptops and in their hand. In the afternoon, the courtmaster will just see if we can accommodate them behind you immediately so they can sit for the day.
Yes, Manoj, that's what Manoj, I was saying.
I just told the courtmaster to find out.
Manoj, who are not appearing, for example,
Also, we'll see if we can even put some stools or something like that.
No, Manoj, some of the councils, Manoj, are not appearing in the matter. They can, Manoj, perhaps accommodate those who are appearing.
But we'll try and put some additional chairs also for the juniors so that they have to be close to whoever is arguing.
Yes. So kind of your lordship. But I am immensely grateful. But entry 20, this is the route. 1990 Government of India Act. Development of industries in cases where such development by a central authority is declared by order of the Governor General in Council expedient in public interest. Development is underlined by me. It is my emphasis. Now come to what happened in 1935. It remains the same. Development of industries where the development under federal control, the word used is now federal control, is declared by federal law to be expedient in the public interest. Federal law is earlier version of parliamentary law. Now, how the drafting committee drafts this entry. Development of industries where development under the control of India is declared by Parliament, by law, to be expedient in public interest. It retains substantial heart and soul, but makes minor changes. Now, please see, how it stands today. And there is a reason. The reason is explained in the Constituent Assembly debates. The word development is replaced by the word control. And there is,
interestingly, if you see our constitution, though, of course, we now know it's a federal constitution. That's how we have interpreted. Constitution doesn't use the word federal anywhere at all. Unlike what happened across the border, if you look at the Pakistani, they have used the word federal government, federal. We don't use the word. We have used central, union, but we have not. We have eschewed the word federal in the constitution.
I think this is my
semantics more than anything else. But at least in the birth of the constitution, they didn't use the word federal.
It's my perception, subject to your lordship's approval. The federalism has several facets. Your lordship, I'm not going on general principles of it is quasi-federal and leaning towards unitary, etc. I'm not on that. When it comes to the subjects which need distribution of national resources, we have, for example, 25 federating units, hypothetical example, 25 states. The classical definition of federalism means each unit is independent in its own way. It's not sovereign in the way American states are sovereign, but they are independent in their own way. Any interference by the center may perhaps not breach the element of federalism which is involved in the constitution without naming the term federalism. But now, kindly see this nuance which is my perception. When the center, having an authority under the constitution, does something to ensure that 3 or 4 states having incidentally major resources of a particular character do not deprive rest of the provinces, namely federating units, of their right of equal treatment, and the center interferes and makes equitable distribution, that is also an element of federalism. So there, to maintain federalism, the power is conferred upon the center. That now you step in. The only condition is the center must have a backing of a constitutional provision to do so. And entry 52 is one such provision. And it is, in my respectful submission, in furtherance of the principle of federalism. Please see page 7. Industries declared by Parliament historically that alcoholic liquor is always spoken of along with other drugs, opium, poison, etc. So in a negative sense, it was considered to be a vice rather than a product. With respect, this is what comes out. This is not my personal view. But that is how it comes out. So, excise, that is to say the control, production, manufacture, possession, transport, purchase and sale of alcoholic liquor and intoxicating drugs. Intoxicating drug can be bhang, which comes subsequently by name, Indian hemp. And the levying of excise duties and license fees on or in relation to such articles, but excluding, in the case of opium, control of cultivation, manufacture and sale of export. So all consumables, alcoholic liquor and intoxicating drugs, which were Opium is also an intoxicating drug which was excluded. Now, the above referred entry makes the following apparent. Entry 16 in devolution rules is a combined entry both for taxing and other purposes. But thereafter, there is a distinction. But I'm sorry, Manoj, kindly pause here for a minute. So far as this entry is concerned, it is a combined entry for regulation as well as for taxation.
Yes.
Which Manoj gets bifurcated subsequently. Second, at page 24, it covered both potable and non-potable alcohol, and therefore there was no distinction between alcohol for human consumption or intoxicating alcohol and alcohol on one side and remaining alcohols, that is non-potable alcohols, on the other side. Alcohol as a generic word, along with its taxing power, was a subject in the state list under 1919 devolution rules. Alcoholic liquor. Now, my lord, kindly come to page 24, para 23. Lord, again, my lord, taxing entry, but now it is split in three heads. Lord, two are taxing and one is general. I did not elaborate much on taxing entry being different from general entry. Hoyt's and other judgments are very clear. This would, I'm sorry,
Yes.
this would also give your lordships, my lord, an assistance. The lordships would have noticed in some of the entries, there are two words used, two expressions used. One is intoxicating liquor. And in taxing entries, the expression used is alcohol fit for human consumption. Alcoholic liquor for human consumption. Why? We were just wondering why. There are two expressions used, but I'll come to that. Now, Lord, Government of India Act 1935, entry 45, list 1. Now, Lord, it comes in list 1. That is the federal government, the central government, so to say, my lord, in present. Duties of excise on tobacco and other goods manufactured or produced in India, except, Lord, now this comes in the exception and therefore goes in second list. So tobacco is central subject. Now please see the expression alcoholic liquors. I'm sorry.
Yes.
First is, kindly see the expression alcoholic liquors for human consumption. Then second, opium, Indian hemp. Lord, Indian hemp is banned. And other narcotic drugs and narcotics and non-narcotic drugs. There are some other non-narcotic drugs having the effect of intoxicating you, but not falling strictly within the definition of narcotic. Then C, medicinal and toilet preparations containing alcohol or any substance. Now, my lord, please see evolution of entry 8, list 2. This was, my lord, the quintessential debate, my lord, which took place. Lord, what was the position in Government of India Act 1935? Lord, there is no similar corresponding provision in devolution rules. I'm sorry. Lord, it was quoted, my lord, at page 23, para 21, my lord. I'm sorry, my lord, I stand corrected. I'm thankful to my learned friend. It was, my lord, I pointed out, it
is a new topic now. Should we begin after lunch? Because this is really now coming into the heart. We've seen now the broader taxing entries use the expression alcoholic liquors for human consumption.
Please.
Because the heart of their submission is entry 8. Therefore, we just want to have a little bit of time to reflect on what you argued earlier.
Yes.
We'll return at 2 o'clock.
There are other issues also I would like to address, but we are now on entry 8, certainly.
Also, on the interpretation, Mr. Mehta,
Yes, ma'am.
intoxicating is the key word, right? So we have a kind of people who has great capacity to consume. They never sort of get intoxicated.
What is the level
Will the interpretation differ depending upon the personal
capacity?
to
It should, my lord. In fact, the Constitution has not taken care of that.
But I shall not fall for that trap, Lord.
My learned friend seems to have a larger capacity. And then
Both the phrases is the word liquor. One is intoxicating, the other is alcohol.
and human consumption.
Yes.
You have to explain the difference between
Yes, sir.
to intoxicating liquor and alcoholic liquor.
Yes.
What is the difference between the two?
And why the word human consumption is used only in taxing entry.
That's right.
That is certain.
So this is a classic case where non-taxing entry becomes more taxing.
Yes, for the my lord God. Yes, your lordship, sorry.
That is what is on.
Shatim.
Obliged.